Good morning, everyone. Today we have another fabulous webinar conducted by the brilliant attorney, Bryan Thomas. This is part 3 of 10, Preserving a Remote Contractor's Lien in Tennessee, the Notice of Non-Payment Requirements. I'm Mariella Wagner, the founder of SunRay Construction Solutions. We help thousands of subcontractors and suppliers secure their lien and bond claim rights. But without further ado, I will introduce Bryan Thomas.
Thank you, and welcome everyone out there. Looks like we're starting to get some more attendees as we go through this series. Wanted to remind you as we go through, as always, if you have questions, please let us know, and I will try to get to them as we go through the various technical details of the lien statutes. Now, that said, just reminding everyone, we are going through a continuing webinar series about lien laws. I'm hitting things along the way, but just so you know, there's some previously recorded webinars if you need to catch up where you are today. And if you need to get into some of the more details, look out for our future webinars as we move forward. Now, as we start each time, I want to make sure we start with what is lienable in Tennessee, and remind you that in Tennessee there's a difference in remote contractors lien rights and prime contractors lien rights, and remind you that it's all based on an improvement to the property, which is relatively liberally construed. Now, what's it on? It's on the real property and it secures the contract price. So those are our basics that we continue to work from each time we discuss the lien rights in Tennessee. Now, today we're going to talk about remote contractors' lien rights and what a remote contractor has to do to preserve its lien rights. It's a little different than the prime contractor that we talked about in April, and it's a little different than what we'll talk about moving forward in terms of perfecting lien rights, which is going to be back similar for primes and remotes. So here we're in the section today where we're specifically focusing on a remote contractor. Now, step 1 for a remote contractor. In Tennessee, it's referred to as a notice of non-payment. This is similar to what you'll see in a number of other states, but in a little different manner. You know, for instance, in Georgia, you have lien waivers that say you are paid unless you file an affidavit within X number of days. This is Tennessee's version of that. And what it is it's a practical requirement through the project that if money is not flowing downstream to remote contractors, to get notice out there on paper to both the prime contractor and the owner. And where I see people trip up on this is they forget about this requirement and it becomes fatal. So let's talk about it. What we've got up on the screen is the actual statutory language, or at least the starting portions of it. Number 1, I'll mention, we've talked about residential projects before. The notice of non-payment is not required on what would be a residential project, and that's really that first preamble you see there in the statute. The second is that it is a rolling requirement. It's required for work performed each month, and its timing is with respect to when the work was performed. And I'll get into this a little bit more, but basically, a notice of non-payment can cover multiple months, but because it has to be served within 90 days of the end of the month when the work was performed, it can only cover at maximum 3 months. So when you've got a situation where you're continuing to perform on a project, you need to make sure you are continually updating your notice of non-payment. So each and every invoice, or really the work included in those invoices, is covered if you get to the point that you need to lien the property. Now, you will see here that we're talking about being when the work or material was provided. Then if things get messy and you're in a lien situation, one of the things that's going to be checked by the owner is when was the work you invoiced for actually performed, and try to get to the position that you're actually invoicing, for instance, let's say in May, for work or materials that was actually provided back in February or March. So there's a real trick there in keeping up with an accounting side of this. And because of that, I encourage notice of non-payments to be sent relatively liberally, both from a practical standpoint, to make sure you're preserving lien rights and make sure that everyone along the chain knows that a notice of non-payment's coming if payment is not received. And it's not something that a remote contractor has a lot of flexibility with, and that a conservative remote contractor is going to go ahead and send one of these notice of non-payments more like 45 to 60 days if they have not been paid. So with that, I want to talk a little bit more about the notice of non-payment. What actually is it? What it is it's a form. You'll see the statutory language here on the screen, and I will tell you there is actually within our statutes, and I believe Ariel has some forms as well with SunRay, a form notice that needs to be filled out that tells the owner and the general contractor a number of things. I will note one of those is the last date cleanup, perform work, or provided labor or materials. Talked about this a little bit in the past, and it's a little vague as to exactly what is required for a prime contractor, but for a subcontractor, sorry, a remote contractor, that would include suppliers as well. The date they last performed is something that has to be in the notice of non-payment. The other thing I will mention here is when you're looking at what's required as far as the owner's name, the prime's name, those can all be just copy and pasted from the building permit. One of the nice things within the Tennessee lien statutes, there's a presumption on the owner's name, the prime contractor's name, the description of the property, that whatever is in the building permit is sufficient for lien purposes. So remember that's there. It's very nice to have. The other thing I would tell you is you can also check if you are a remote contractor. The prime needs to be licensed, and you can also get information as far as mailing addresses and the like from verify.tn.gov. So that's a secondary source that you can't get your hands on the building permit. The other question is going to be, well, how do I have to send this notice of non-payment? I'm going to cover this in a bit more detail here in a couple minutes, but for purposes of talking, really any form that is recognized that provides confirmation, whether you're talking about priority mail, whether you're talking about UPS, FedEx, DHL, any of those that are going to have confirmation provided to you will work. So will some other forms, and again, we'll talk about that in a couple of minutes. Now, what I want to enforce and reinforce is the failure to provide these notice of non-payments along the way have very severe consequences, in that a remote contractor simply loses its lien rights. That is a big deal, particularly when a remote contractor is in a situation and is not being paid because the owner is paying the prime and the prime's not releasing, or the prime is in big trouble. Here in Tennessee, there's a case out of 2015, the Diaz case, that basically says notice of non-payments are substantive, and if the remote contractor does not provide the statutory required notice to both the prime contractor and the owner, they simply do not have lien rights and will not make it past a motion to dismiss stage in the lawsuit. That is very important for a number of reasons, including the fact that if you are a remote contractor liener bringing a lawsuit, again, we'll touch base on the lawsuit here in June, that you can actually be liable for all costs and attorney's fees, not just associated with the lien and the placement of the lien, but also the lawsuit as well. Now, I want to give you an example because a lot of this, you hear it and sometimes hard to put it in perspective. So I put up a hypothetical on the screen, and it deals with a situation in which a remote contractor has provided some materials mid-January, some working materials by the end of January, which they invoice in February, and then again in February they perform more work and invoice it in March. A pretty typical type fact pattern you would see from a remote contractor, particularly sitting here in May. And let's say in late May, well, I'm a remote contractor and I decided I'm going to send a notice of non-payment June 1st. My accounting department's got it calendared, we're good to go. So the question that I've got is, well, is sending a notice of non-payment on June 1st preserve all of that remote contractor's lien rights? And as we go through this, you start thinking, well, what about the January 10th material? Well, under the notice of non-payment, we would go to the last day of the month of January, and then we would add 90 days to that. So it'd bring us to the beginning of May. So sending a notice of non-payment on June 1st is not going to help. In fact, you would already have lost, or the remote contractor would have already lost their lien rights because they hadn't sent a notice of non-payment by roughly May 2nd, or 90 days after January the 31st. Now, what about the 25? Well, it's going to be the exact same analysis. And the answer is, if the remote contractor had not sent a notice of non-payment by early May, that $25,000 as far as lien rights is already gone. What about the $125,000 delivered on February the 10th? Well, again, this one is going to be really dicey if you're sending the notice of non-payment as of June 1st. Then why I say that is the analysis is this. If the material was delivered February 10th, you get the benefit of the entire month. So we're going to go to February 28th, 29th on leap years. Then we're going to add 90 days from there. And what I will tell everyone when you're talking about liens, if I start having to go to the rules about exactly when delivery was made and whether the day you send a notice of non-payment counts, we're in trouble. So what you need to think about here is there may be some exceptions for a June 1st notice of non-payment where we could say on some accounting rules that the notice of non-payment for that $125,000 would be good. But what I would suggest to you, if you were in this situation, that here on May the 20th, you should go ahead and send the notice of non-payment so that you certainly have rights in the $125,000 delivered in February. Now, I know all that's complicated, but the moral to that story is this. You've got to have a very quick turnaround within your accounting department as a remote contractor to understand what has not been paid and make sure that notice of non-payments are going out, and that they are going out to not only the general contractor, but also the owner as well. So I'm actually going to pause and say one more thing when we're talking about the notice of non-payment. And I meant to mention this earlier, but it's the last bullet here, and it's in the notice of non-payment statute. And it's the fact that the notice of non-payment has to go to the owner and the prime contractor. One thing that we will talk about here in a minute with step 2 is the owner is a very broadly defined entity within the Tennessee lien statutes, and will include a lender who has a deed of trust or anyone else who has claimed a lien or reported a lien, whether that be a judgment lien, a tax lien, or in this respect, another entity which is claiming a material mens lien on the property. All those people have to get the notice of non-payment, as well as our step 2, which is going to be a notice of lien. And you'll see the notice of lien. First thing I want to point out is a notice of lien is different than a notice of non-payment, and statutorily the notice of non-payment cannot serve as the notice of lien. They are two different forms, both of which have to go to preserve a lien right, preserve lien rights for a remote contractor. Now, the requirement for a remote contractor is to serve a notice of lien on the owner. And again, the owner is going to be anybody with a legal or equitable interest in the property. Now, what that doesn't say is you have to record a notice of lien with the Register of Deeds. What I will suggest to you is this, that if a remote contractor gets to a notice of lien standpoint, they should both send and serve the owner and record the notice of lien. Now, the references within the statutes all point you back to 11-112A. And 11-112 says that the notice of lien, again, different than the notice of non-payment, needs to be sent, well, actually within 112, it's recorded within 90 days of the day the improvement is complete or abandoned. There is some argument within Tennessee practice as to whether that includes the work of the remote contractor or the work on the project. I think the answer is likely to be, from any court looking at it, that it is the date the improvement as a whole is completed. That said, there is an argument for an interpretation by a court to say that it is the improvement that is being liened by the remote contractor, and thus it should be 90 days after the remote contractor completes or abandons the project. And from a conservative view, that is what I recommend. That said, if a lien has not been filed by a remote contractor within 90 days of the completion of their work, I would still suggest the remote contractor continue to lien the property so long as it is within 90 days of the date of the entire improvement. And again, the reference over to section 112 for remote contractors is a good reminder that even if the court says you didn't have to record your notice of lien as a prime contractor based on the statutory language, the remote contractor is going to lose their priority in a lien to anybody that comes along and buys the property, which is a very important aspect of the lien itself. So again, notice of non-payment, we're going to serve that on the owner and general contractor. Notice of lien, we're going to serve that, and we're going to go ahead and record that with the Register of Deeds. Now, the references here to completion, we talked about these a minute ago. I just want to remind everyone that the 90 days from completion for recording the notice of lien, this is step 2, has some differences in the case law, but the case law generally says that, look, punch work and warranty aren't going to extend out the time for which you have to serve or record your notice of lien against the property and to the owner. The other thing that you have to be aware of as a remote contractor is if the project goes to a standstill for some reason that the remote contractor does not know, be aware that there is potential for lien rights to be cut off if that lapse is more than 90 days, based on the content of the discussion that's going on between the owner and prime contractor. So as a remote contractor, if there's a pause in the work on the entire project for 90 days, the remote contractor needs to be thinking about going ahead and proceeding with step 2, which is actually serving and recording the notice of lien. Now, I told you I'd get here, but the question on how to notify. Luckily, there is some guidance within the Tennessee statutes that tell us exactly what's going to be acceptable. That section is on the screen for you. It is pretty broad. What I would suggest to you, the biggest problem I see is not someone forgetting to serve by one of these methods, but instead it is failure to keep the records. So if you're going to send out, again, this is notice of non-payment as well as the notice of lien requirement. If you're going to send them out, remember to send them out in some way that there's confirmation of delivery and that the confirmation of delivery is kept in some way. Now, a lot of people use green cards and things like that, and so long as you have the original green card, you can get back to the confirmation of delivery with the delivery services website. But we've got to have that documentation as a remote contractor lienor. Now, that's step 1, notice non-payment. Step 2, notice of lien. Step 3 is the attachment of the property and the commencement of the lawsuit. And that is a rolling requirement for remote contractors from 90 days of the date the service of the notice of lien is provided. So the earlier that the property is liened by a remote contractor, the earlier that the lawsuit and the attachment has to be filed. So those two are interlinked for remote contractors, and again, different from the prime contractors we discussed last week. So with that, I'm going to tell you there's a lot to talk about in the sense of lawsuits and the attachment in those requirements, what exactly is required. We will get to that next month, and I'm glad to go over any questions, but we will go through that in full detail next month. Tune in. Now, I want to give you a quick summary. Step 1, notice of non-payment. It's 90 days after the end of each month in which the work was performed or the material delivered. So that's the first thing you got to do as a remote contractor to preserve your lien rights. Then you have to serve, and I prefer strongly record the notice of lien within 90 days after the improvement is completed or abandoned. And then 90 days after you do that, or within 90 days after you do that, you have to file the lawsuit and the attachment. I've got a last note here that says beware of bond deadlines, and we'll get into this again in a couple months. But one thing you've got to be aware of as you're looking at all this and the timing for a remote contractor is, was there a payment bond posted on the entire project to defeat any lien rights? And if so, make sure that you know what is in that payment bond that has been recorded and that you don't miss some deadlines in there, presuming that the general lien deadlines are governing. Now, we went over this last month, and I'll just mention it again. The sequence I just gave you, the notice of non-payment is not going to change, but the notice to serve and record your lien and the notice to, or in the lawsuit and attachment perfected, can be shortened either by the owner and or the prime contractor, depending on exactly what we're talking about. So with that, I'm going to open it up to questions or answers. And Ariel, you can tell me if we have anything this morning.
So
Otherwise,
far, we
we will
don't have
roll
questions.
to our next session and see everyone back in June.
Sounds good. We don't have any questions so far, but one of the pieces that I'm surprised this question wasn't asked was the notice of completion and the shortening of the deadline. One of the issues that could occur is how does one know that there has been a notice of completion that's been filed?
So that's a great question, Ariel. The answer is for the prime contractors whom we talked about last week, they are required to receive a copy of it. For remote contractors, the owner is only required to serve a notice of completion on remote contractors if that remote contractor has served the owner properly with a notice of non-payment. So one has knowledge if they have filed a notice of non-payment. But if we get to a pretty typical scenario where a remote contractor has been paid along the way, but there may be some slow payments at the end, a remote contractor has to be very aware of completion because the notice of completion may cut off their rights before they were ever even required to file a notice of non-payment or a notice of lien. So if you get into the project as a remote contractor, you have to be very careful on that notice of completion requirement.
Very good. You know, all the states have such different requirements, and the notice of non-payment really allows for a lot of time. So what do you tell your clients, you know, say 90 days from the last invoice date? Do you recommend, instead of waiting that long, really implementing a process in the company so that people start sending notice of non-payments really no later than, say, 45 days or 60 days, and have an internal process so that they do secure their lien rights?
The answer to that, Ariel, is yes. And it really needs to probably be within the accounting department that is seeing the AR reports. And what trips a lot of people up with Tennessee, you mentioned from the date of the invoice. In Tennessee, that trips a ton of people up because in Tennessee, it is the date in which the work was performed or the material delivered. And that's why I really encourage, yes, there's this 90-day tail upon the end of the month in which it was delivered. That said, 60 days after the end of the month in which you think you've covered by an invoice, I suggest that you go ahead and have served a notice of non-payment. And again, a notice of non-payment is more like a letter than something that is actually encumbering the property. And I know there's always the tension of preserving rights and preserving relationships, and that's something you've got to work through. I think the Tennessee law, the requirement that this go out helps ensure that all parties are talking and that notices are going back and forth so there aren't surprises in the payment process, particularly between an owner and a remote contractor, or even in some sense between a general and not their direct remote, but a remote under them.
Great. Well, thank you so much for clarifying that. I know that that's a question. You know, we do have, someone just asked this other question. Is the date of the certified letter being mailed considered the date the note was given?
So yes and no. I'm going to go back to the statute that specifically deals with the notice. And the D part here is, I think, the question that they are asking. It's when is service complete? And you'll see the various rules depending on which service was used. What I again recommend is when I'm talking about lien deadlines though, if you sent the letter out, I would count that as day one. I wouldn't even count it as day zero. And I tell you that from the purpose of, if you're going to file a lien to perfect rights in the property to make sure you get paid, the last thing that a remote contractor wants to be fighting about is whether it's a notice of non-payment, the notice of lien, or the lawsuit, whether they were filed on the last date or the first date out. Instead, you want to be clearly within the date to avoid the time and the energy with the fights.
Great. Respondent, thank you very much. Well, again, wonderful webinar, extremely informative. If anyone has any questions, concerns, Bryan's email, of course, I'm available as well, but you could see Bryan's email and phone number are there. Bryan, thank you again. Just a spectacular webinar.
Thank you, everyone. Have a great day.
Thank you.